Hello friends, this is Priyanka from CS Priyanka's professional classes. I promised in the last video that I am coming very soon with part 2 video of directors. So today I am here with director part 2 where I have included the topic only DIN, and whatever leftover items will be there like removal, resignation, vacation, those soon I will come with another video, that is part 3. Hope you will be benefited. If you like my video, please don't forget to click on the like, please subscribe to get more videos, and please, if you feel it is beneficial, then please share with your friends. Thank you. Let's start. My today's topic is Director Part 2 from Companies Act 2013. Today we are going to discuss on the topic DIN, that is Director's Identification Number, which is one of the main requirement for all the directors to obtain. Okay, so without DIN number, director actually is not a director, or director cannot be a director. DIN is one of the main requirement to be a director. First section from directors I would like to discuss, that is section 153, which denotes application by directors. This section will tell you those individuals who want to be appointed as a director in a company. First of all, they should obtain or possess DIN number. DIN number is nothing but a director's identification number. From where they will get? They will get from ROC by filing an application. Now that application, that application is mentioned under section 153 of Companies Act 2013. So first point is, every individual who are intending to be appointed as director needs to make an application in form DIR3 for allotment of DIN to the central government along with fee. So what happened, whenever a director wants to obtain DIN number, they will file DIR3. So how we file DIN? Actually, we intimate to ROC by filing all these forms in the website www.mca.gov.in. So some forms are there which are directly goes to central government, and some forms are there which are actually goes to ROC or indirectly goes to central government via ROC. So whenever an individual wants to be appointed as a director, that person needs to make an application in the form DIR3. How we will get DIR3? You have to go to the website www.mca.gov.in. There you will get a tab like downloads form. From there you have to download the form DIR3. You have to fill the form online and you have to submit along with the fee. Okay, and normally the form is going to the central government, and central government will issue DIN number within a month, okay, or like within a month or within a specified date as per act. Second point is, in the event of any change in his particulars as stated in form DIR3, intimate such change to the CG within 30 days from such change in form number DIR6. Friends, first point is clear that whenever any individual wants to obtain DIN number, they needs to file an application. Now, application means we usually don't write in a white paper letter or something like that. There are specified forms given by the government. Those forms need to be filed with the CG or ROC, and this is the way of communication between a company and ROC or CG. Now DIR3 also one of them application, that individual will file DIR3 along with fees to central government. Now think, once that individual filed DIR3, after filing DIR3, any change in particulars happened. For example, like an individual shifted the residential address, or else the change in phone number, or else any ID card change, or any girls after marriage change the surname, any change can happen in the particulars. In such cases, within 30 days of filing DIR 3, such individual will intimate such change to central government in form DIR 6. That is also within 30 days of such change. Next section is section 154. In 153, we have read कि we filed an application for obtaining DIN. Now already you filed. Now you are waiting for your DIN number. That means central government needs to issue that DIN number to that individual or to you. So that is known as allotment of DIN by central government. That is specified under section 154 of Companies Act 2013. So first point is central government on receipt of such applications within 1 month central government will issue you the DIN number, okay, in such manner as may be prescribed in the act. So whenever you will file an application from that day onwards within 1 month it is expected the central government will issue DIN to you. Okay. Now on receipt, the director on receipt of the DIN from the central government within 1 month, every director needs to intimate about such DIN to the company or all companies wherein he is a director. And how will we intimate to such company? There is also a different form, that is form DIR 3B. DIR 3B. So what happened? What director will do after obtaining DIN? He cannot sit at home, right? Once he got appointed in a company, after that only he applied for that DIN number. So once government allotted the DIN number, he should intimate such company, na? Why here I have mentioned it, he needs to intimate the same to the company or all companies, because if the director is a whole-time director, then okay, in one company he will be the whole-time director like a full-time employee 10 to 5. But if a director is a non-executive director, that means a part-time, then he can act as a director in maximum 20 companies. So where once he get the DIN and wherever he is appointed as a non-executive director or part-time director, he should intimate to those all companies, okay, in form DIR 3B. So what we read, section 153 is relating to the application to obtain DIN. 154 is government is issuing DIN to you. Okay, once you receive the DIN from the government, you should intimate to the companies where you are going to be appointed as a director or else where you are a director. Okay, and that is you will intimate to such company within a month in form DIR 3B. So this is a continuation of the last slide. Next point is telling the company will intimate about the DIN of the directors within 15 days in form DIR 3C. So on receipt of the DIN number from the directors, company need to intimate about that DIN number to everyone. Everyone in the sense like all other authorities like ROC or bank, bankers, other clients, okay, that work company will do within 15 days in form DIR 3C. So I already said key forms means like it's a mode of communication between company and the authority. Next point is central government is having power and right to issue DIN number to an individual who is going to be appointed as a director. Similarly, central government is having right to cancel or deactivate such DIN anytime on the following grounds. Only this power is central government is having. So what are the grounds are there on the basis of which central government may cancel or deactivate the DIN? Point number one, like DIN is found to be duplicated in respect of same person. For example, a same person obtained two different number, okay, as DIN. So actually we know ki executive or whole-time director is a director cannot be a director of more than one company, or means for him or one DIN is okay. Now those who are non-executive director, that is part-time, one director can be a director of maximum 20 companies. Now, as per Act, same number will be allotted to him for 20 companies, not the different 20 numbers. Clear? So, an individual should have only one dean or only one number, and with that same number, he can be a director of maximum 20 companies. So, in case any dean is found to be duplicated in respect of the same person, that is a one ground of cancellation or deactivation of the dean by the government side. Second point is if an individual obtained dean by a fraudulent means. Okay, that means you have the while obtaining dean number, you have not followed the specified sections provisions of the act. Okay, so specified sections in the sense like whatever we did before, like what are the application allotment, all those sections forms, whenever we are obtaining anything, we have to go in a through a procedure. Okay, so whenever you are not following any procedure or process, so in such cases what happened, by fraudulent means I have obtained some dean number, that can be also a ground of cancellation and deactivation of the dean by the central government. Next is after applied, whenever I applied for a dean or after obtaining dean, maybe the individual died. Okay, in case of the death of such concerned person, individual, central government on receipt of the death certificate may cancel or deactivate the dean of such individual. Last one, the concerned individual has been declared as a person of unsound mind, insolvent by the court. Now, if a person becomes unsound mind in the sense you can say it's a more mad, or else you can say that person is having not having any decision making capacity. Okay, that means he cannot take decision like a normal person. We call them as an unsound mind. If such person declared as an unsound mind, that is also a ground of like deactivation and cancellation of dean by the government. Or else if such person is declared as an insolvent word means unable to pay debt. And whenever any person becomes insolvent, it is a main point of disqualification. So whenever such person becomes insolvent and declared by the court, that in such cases also central government may cancel or deactivate the dean of such individual, concerned individual. Now next point, the central government is having power to deactivate dean. Okay, that we read in point number 4. But sometimes it happens like the directors or the individuals who are having dean number, that person wants to surrender his dean due to some reason, or he becomes disqualified, or he don't want to continue as a director. And many grounds and many cases are there. Now think, being a director, for example, like I'm a director, being a director, I don't want to continue as a director anymore. So in such cases, I want to surrender my dean before the CG. In such cases also a one application form is available in the website, that is DIR5. I need to download such form DIR5 from the website, MCA website. I need to fill it up and I will file the such form along with the fee. And such form, whenever I will submit on receipt of that form by the central government, okay, so that is a form of surrendering my dean. Okay, so whenever I will surrender my dean through that form DIR5, central government may deactivate my dean. After section 153, 154, now comes to section 155. Now what this section is telling? Section 155 is Section 155 of Companies Act 2013 is telling about the prohibition to obtain more than one dean. That means one person cannot obtain more than one dean for number of companies also. Like as per Act, a non-executive director can be a director of maximum 20 companies. Now more than one up to 20. Now for that also, that such individual will obtain only one dean for all the companies. That prohibition is there to obtain more than one dean. So any individual who has already allotted a dean number under section 154, whatever we discussed, The such person are totally restricted to obtain or possess more than one dean. So a person cannot have more than one number. Maybe he is a director of more than one company. Section is section 156, which says directors to intimate dean. So this means whenever director when director receive dean number from the government, that means directors uh, made an application form or submitted an application to the CG, central government, for obtaining dean. Now on receipt of the application, CG allotted dean number to the director. Now section 156 is telling the director, on receipt of such dean number from the central government, he should intimate about his dean or his dean number to the company or all the companies wherein or wherever he is a director. So he should intimate such dean to the company where he has appointed as a director or he is going to be appointed as a director, or any number of companies where he is acting as a non-executive directors, or he is going to be acted as a non-executive directors. Next, section 157. Whenever company, 156 was telling ki on receipt of the dean number, director should intimate about such dean to the company or to all the companies wherein he is a director. Now 157 is telling company, on receipt of the information about dean from the director, company will intimate about that dean number, okay, within 15 days to all other authorities. Okay, so or authorities in the sense ROC also. So company 157 is relating to such things like company will intimate on receipt of the dean number from the director, company will intimate to ROC, registrar of companies, within 15 days. 158. Obligation to intimate dean. Obligation means liability. So what are the liabilities are there? That means when and what is the what are the liabilities, okay, and when you are, that is must or mandatory for you to mention the number. So this is all about that, what are the information, what are the particulars information, documents where the company needs or mandatorily needs to mention the dean number, or about intimation about the dean. That is an obligation, liability. Okay, and obligation, wherever there is obligation, punishment will come. That means if he fails to fulfill the obligation, penalty will be there for that person. So section 158 is telling about the obligation to intimate dean. 158, section 158 is telling every person or company, such while furnishing any return, whenever they will file the annual return or any information or particulars relating to the or which is related to such company, and wherein the such director is involved, such information, particulars and return, that company or individual are required to mention dean, director's identification number, in such written information or particulars. In case the wherein the director, okay, or containing reference of the director, because normally the director's report and everything usually signed by the director. So wherever you are referring the director, DIN number is mandatorily needs to be mentioned in such instrument or documents or annual return, or else in particulars or any details or any other documents of the company. Last section we will read under DIN, that is section 159, punishment. Obviously, whatever sections we read till now, like 152, 155, 156, 154, 153. Now this 159 is like that, wherever you are having obligation to do something and you have not done. So if any individual or director of a company contravenes any of the provisions of any section, like whatever we read under section 152, 155, 156, then obviously that person or individual is in default, right? And whenever that person has not followed the rules, shall be punishable with the imprisonment and fine. Imprisonment means jail or fine, mentioned below. What is that? Whenever that person has contravened means not followed Okay, the rules and regulation. Jail will be maximum 6 months, minimum not prescribed. Okay, on the basis of criminal act. Fine will be maximum 50,000, minimum not mentioned. Now, this is the first case. Now, if you further contravention, then you have repeated your mistake, or you have contravention, you have repeated your contravention, further contravention. Okay, if you do second time same mistake, then 500 per day will be charged as a fine along with the existing fine structure.